Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We are talking about the new Supreme Court case that has struck down the BIA's policy for applying 212C relief. And I want to get into some specifics as to why. They basically say that the comparable grounds approach, which is again where you have a crime that they're trying to show is deportable, but they're saying that there's no equivalent excludability ground. They're saying the comparable grounds approach cannot survive scrutiny under the standard of showing that it's basically reasonable and not arbitrary and capricious. The Supreme Court says by hinging a deportable alien's eligibility for discretionary relief on the chance correspondence between statutory categories, a matter irrelevant to the alien's fitness to reside in this country, the BIA has failed to exercise its discretion in a reasoned manner. And I mean that's a great ruling to show that there needs to be some basis for what they're claiming. And it says even if the BIA has legitimate reasons for limiting 212C's scope in deportation cases, it must do it in a rational way. In other words, the BIA must use an approach that is tied to the purpose of the immigration laws or the appropriate operation of the immigration systems. And it says here that the Supreme Court says that the comparable grounds rule has no connection to these factors. Instead, it makes eligibility turn on an absolutely irrelevant comparison between statutory provisions. So, in this particular case, it's a great ruling. It's right on point as far as why it struck it down. And now, if you can apply for 212C relief, you should go forward because you don't have to have that, silly, arbitrary ruling by the BIA anymore.